Okay, in this video, this gentleman is discussing promissory notes and bills of exchange and the acceptance in the public of these instruments. Now, this is not a critique of him. I've been doing this 20 years. I see individuals like this all the time talking about these particular topics. He's right on some things, and some things I think need to be elucidated a little bit. So I'm going to try to assist in that endeavor with this short video. Let's look at it. Let's see what he's talking about.
Besides, if banks are doing promissory notes and bills of exchange, then why can't we do it? And we can do it. I'm helping another guy at the moment where they're basically saying you can't deliver a promissory note because the promissory note's not backed by any substantial financial institution. And if you swallow that line, then you've accepted the offer. Did we accept it? No. Since when is your birth certificate not an adequate financial institution, being a bond? And does it not have unlimited credits attached to it? And did your promissory note, was it not supported by a birth certificate number? Therefore, are you not a banker, pursuant to Section 4 of the Bill of Exchange Act, being an incorporated or unincorporated body of persons involved in the business of banking? So that's what we ask. Are we not an unincorporated or incorporated body of persons involved in the business of banking? Therefore, are we not a banker? And was the promissory note not supported by a strong financial institution by way of a birth certificate, being a bond? That's called holding your position for those that are new and for those who are not new. So that's how you hold your position.
Okay. A lot to unpack here. Okay. An individual like this, when I see them, they have some experience in doing this. I'm not going to say he doesn't have any experience, but I'm not going to estimate how long I think he's been doing it, but he hasn't gotten some clarification on a lot of things. Like, this is what becoming a secured party creditor does. It helps you get a clear clarification on all of this. I shouldn't even call it secured party. It's really private banking. You're setting up a private bank account, and then you're issuing negotiable instruments, and you have a value that is attached to those instruments. You see where all of it is done. You understand the entire process from beginning to end. So what I'm going to do now, I'm going to replay this again, and then I'm going to pause the video at the points that I think the salient points that are most apparent to me that need to be explained a little further. So let's just dive in a little bit. I'm gonna start it all over. Let's go.
Besides, if banks are doing promissory notes and bills of exchange, then why can't we do it?
Yes, we can do it. However, there is a caveat to that. There is a public and a private, and they don't mix. Okay, they don't mix. When you go into their jurisdiction, they have a private jurisdiction too. It's called the public, but it's really like a private jurisdiction. The reason I'm saying that is this. The Constitution for the United States of America only allows for gold and silver to be utilized for the payment of debts. They understand that. So they had to remove you from that constitutional protection. And the only way they could do that is by taking you into a territorial jurisdiction where they exercise what is called plenary power, which means they're all powerful. And that is a term that applies to the world of commerce, specifically the federal government and their exercise of regulating interstate commerce, okay, which interstate commerce applies to almost everything. And not just anything that touches interstate commerce, they have a right to regulate. All right. So the first thing you got to get in your mind is this public and private demarcation line that separates both realms. You have to understand in their realm is a territorial jurisdiction. That jurisdiction was carved out in Article 1, Section 8, Clause 17, where it talks about the 10-mile square in Washington, D.C., American Samoa, Guam, Puerto Rico, all the forts, magazines, U.S. district courts, post offices, and the social security number. All right. That's their property too. So all that falls within their purview of their power to regulate. You don't have any power to come into the public and dictate anything. Let's make that clear. Separation of public and private. The principle you should remember is the superior man stays in his own domain. Let's keep going.
And we can do it. I'm helping another guy at the moment where they're basically saying you can't deliver a promissory note because the promissory note's not backed by any substantial financial institution. And if you swallow that line, then you've accepted the offer.
Now, this was a very, very good point that he brought up, and that you will run in and encounter. If you've ever done a debt discharge, you're going to run into this a lot, at where they say, well, there's no substantial financial institution associated with it. Now, in private banking, when we set up our secure party process, the first step is to send a package to the Treasury Department because we're going to get an agreement from them, a stipulation that it's going to be okay for you to go into their jurisdiction and issue instruments. And we're going to do that by tendering them a bond and making it a two-way transaction. All right. We're giving them a benefit for accepting the bond, and they're giving us a benefit. One of the good documents for you to read to understand this process is Byron Beer's What Does Acceptance for Value Mean?, where he explains how we give them private credit in exchange for public credit. All right. It's called negotiable instruments. Negotiable instruments are contracts. A contract requires offer, acceptance, and consideration. Where did I get that from? First line in Bills and Notes in American Jurisprudence. You can go and read that for yourself. Okay, right now. Go over there and read it. And so the thing you want to understand is they do have grounds for saying what they're saying. However, if you have, before you did any of this, you went and did your process, your private banking secure party process, where you tendered a bond to the Treasury Department, you gave them notice. See, when you give the Treasury Department notice, you can't be charged with criminal intent or mens rea, because how can somebody say you intended to commit a crime when you gave them plenty of notices of what your intentions were? So before you ever start uttering instruments, the first thing you want to do is you want to get in contact with the Treasury Department, let them know what your intentions are, make an offer to them, whether they accept it expressly or by silence, it does not matter, because those terms will be expressly stated on the tenor of that bond instrument, which constitutes a trust document. This is why back in the day we called it a UCC contract trust. A lot of you think trust have to be written in a certain way. Trust can appear in any kind of way. Any kind of way. It doesn't even have to be called a trust to be a trust. Just the elements need to be available for it to be a trust. It needs to be a settlor, someone who's creating a fiduciary relationship with another individual for the benefit of a third person. Okay. In our case, we're the settlor, the trustee is the Secretary of Treasury, and the beneficiary is the straw man and the United States. All right. So, just want to get that little rattling around in your head a little bit. Okay. Now, he's also correct that if you, a lot of times they're going to give you excuses for things, and you're going to always have to respond to what they're doing. You need to respond within 72 hours. You never allow longer than that. 72 hours after you get a correspondence back from these individuals and you see their ridiculous response, you need to respond to that immediately. I would suggest that you give them some sort of organic response, not any type of boilerplate document response or anything like that. What you will start to notice is that you will start to get individuals who will respond to you with a blue signature on the paper, not just some sort of computer generated response. You don't want to get that. When you start getting that, you know they're starting to take you a little bit serious. Let's check out and see the rest of this.
Did we accept it? No. Since when is your birth certificate not an adequate financial institution, being a bond? And does it not have unlimited credits attached to it?
Okay, this section right here, the birth certificate is not a bond. All right, it's not a bond. However, it does evidence that there is a real living soul who is alive, capable of producing labor. And that is what gives value to a bond. The reason we claim the birth certificate in the secure party process and we send it to the Treasury Department is to a copy of it. You don't send the actual birth certificate to them. You send a copy to them because each birth certificate has a unique serial number on it. Every new copy of a birth certificate you get has a different serial number on it. You're the only one who can get that copy as well as your parents. You're the only two people who can get it. Once you get that birth certificate and you send them a notice, you're going to put that on a UCC1 and claim it. A UCC1 is just a notice. That's all it is just a notice to establish a priority perfected interest in personal property. That's all it's for. And you just can't file just a UCC1. You also have to send them a copy of your filing. Where did I learn that from? That's UCC 1-302, which is the holder in due course. When you're dealing in negotiable instruments, you need to understand what a holder in due course is in order to understand UCC 3-305 and UCC 3-306, which are claims to an instrument, UCC 3-306, and claims in recoupment, which is UCC 3-305. All right. You have to understand those things. However, we create a birth certificate bond. All right. The birth certificate bond gets its value from your labor. That labor, the value of that labor is captured on a UCC1 in the form of a claim. Okay. So we have a priority perfected interest in property. That property being your labor. Your labor is your property. No one can establish the value of your labor. Everyone's labor, a workman is worthy of his hire. You might be the next person to discover the cure for death and become a multi-trillionaire. No one knows. No one can tell you what your value is. They can tell you what your minimum value is. That's why they have a minimum wage. But they don't have anything of a maximum value of what a person is worth. So you're worth whatever you say you're worth. All right. So if you want to give them $100 million bond, as he's saying right here, we use the word exemption, which is unlimited. It's unlimited credit. All right. Because it's a promise to pay. Okay. In other words, you're saying we'll give you this money back once you put gold and silver back in circulation, which may never occur. Okay, never occur. So this is all falls under HJR 192 of June 5th, 1933, Public Law 73-10, and all associated policies. All right, but you need to understand how to do a private banking process to get a little bit more in-depth understanding of exactly what he's talking about. All right, let's keep going.
And did your promissory note, was it not supported by a birth certificate number?
It could be in a certain kind of way. I wouldn't say a birth certificate number. The birth certificate number is put on the UCC1. The UCC1 constitutes a priority perfected interest in property or a claim. Notice that claim is sent to the federal government. That claim, the value of that claim is put inside of a bond. Same thing that they do. Same thing that they do. You can read the Financial Accounting Standards Board Statement number 95. Go to page 21 of the financial institutions, and in there, you will see that banks create money through lending. So everyone is looking for an opportunity to create a debt obligation, whether it be the courts, which you also call banks. A charge is a lien. Get a Black's Law Dictionary, 12th edition. Look up the word charge. Under the 5th sense, you'll see that it is a lien. A lien is evidence of a debt. A debt creates a creditor and debtor situation. All right, which the creditor, if he securitizes that and becomes a secured party, meaning that he does a step-by-step process where he gives notice to the world that he has a priority perfected interest, first in line, first in time in that claim, he can take that claim, put it in a bond, discount it, and trade it on the markets. You're doing the same thing. This is why we say, I'm more than competent enough to handle my own commercial affairs. That's why you're saying that. You're demonstrating competency in commerce by understanding securitization, how to monetize instruments, how to be a private banker. However, a birth certificate in and of itself is not a bond. However, it is evidence of a real living soul. Real living souls have value because of their ability to perform labor. Okay, let's keep going.
Therefore, are you not a banker? Pursuant to Section 4 of the Bill of Exchange Act, being...
Okay, I don't understand why we're talking about the Bill of Exchange Act. All this comes from the law merchant. Law merchant has been around for thousands of years. Bill of Exchange Act. Now, let me just say this. This is public and private. That's an act, has nothing to do with us. Private individuals, we deal with contracts. This is why we notice the government first in our first step. The first 30 days, we send a package to the Treasury Department. We're establishing an agreement of the parties with the Treasury Department. Private individuals work through contracts. We don't have anything to do with statutes, codes, rules, and regulations. Public and private does not mix. Remember that.
And incorporated or unincorporated body of persons involved in the business of banking. So that's what we ask.
Okay, I didn't get the incorporated part, but yes, unincorporated is a synonymous term with private. But you are a private banker. I will agree. I don't know about corporated. I don't know. Maybe he's referring to the straw man, but the straw man cannot speak or anything like that. Let's stop using the word straw man too. Let's start using the word juristic persona. Juristic persona. Let's start using that word.
Are we not an unincorporated or incorporated body of persons involved in the business of banking? Therefore, are we not a banker? And was the promissory note not supported by a strong financial institution by way of a birth certificate, being a bond?
Okay, I agree that it is supported by a strong financial institution, that institution being the Treasury Department. When you submit a negotiable instrument to set off an obligation, there are 19 different ways to set off a debt or discharge a debt, by the way. Where did I get that from? Get you a Black's Law, 4th edition, or Bouvier's 1856, and look under discharge of contract. There is no word discharge debt in a law dictionary. The term, the legal term is discharge of a contract. Why? Because negotiable instruments are contracts. Where did I get that from? Bills and notes. Very first sentence in the book. Bills and notes, promissory notes, and bills of exchange in all their forms are contracts. Okay, they're contracts. So you're discharging a contract. Why is it a contract? Because it's a negotiable instrument, which means there has to be an agreement of the parties. All right. You can't force a corporation to take this. And this is why you need to provide them with processing instructions. You never give a negotiable instrument without processing instructions. You got to tell that entity where to take that negotiable instrument. Also, all of this documentation, hopefully all this correspondence is documented by you with certified mail with an affidavit of mailing. So you can go into the courtroom. What you want to know is whether or not they made a presentment. See, under the rules of negotiable instruments, when you give somebody a negotiable instrument, they must make presentment. And then if there is a defect in the instrument, they have to return it to you with such evidence and allow you an opportunity to cure. So if you're in court, you say, Your Honor, objection. Counsel needs to take that to his client and they can return it to me with evidence of a defect from a qualified third party and allow me an opportunity to cure. Who's a qualified third party? Notaries. This is the reason notaries are in the bank. Notaries do notarial protests on negotiable instruments. All right, let's keep going.
That's called holding your position for those that are new and for those who are not new.
Now, he's absolutely right about holding your position, staying on your, staying in your square or standing on your square, or however you want to hold it. You cannot be shaken. I had a judge actually tell me that one time. He said, you know how a game goes, Mr. Jones. They're trying to get you to do their thing. You're trying to get them to do their thing. They're trying to get you to do their thing, and you're trying to get them to do your thing. And that is what is going on. This back and forth with the correspondence that you're engaging in. They're trying to get you to agree to their terms, and you're trying to get them to agree to your terms. This is why it's vitally important that you respond within 72 hours, because the contract forms within 72 hours. Regardless of how much time they say that you have to respond, always use 72 hours. Now, why is it 10 days? That's 10 days mailing time for them to get it, 3 days after they get it for them to return it, and then 3 days mailing time to come back, and 1 day for Sunday. Now, that time may be modified if it is something that you are dealing with that is regulated by a statute like the Fair Debt Collection Practices Act, which I believe they have about 20 days to respond to a correspondence. So 10 days would not apply in that situation. Okay? All right?
So that's how you hold your position.
Okay. Very good. You got to understand, I've been doing this 20 years. I've read all of these books. I've done all this stuff myself. I got not just book knowledge. I also have a lot of courtroom experience as well as, dealing with these negotiable instruments. I can create them from scratch. A lot of the ones that are circulating around, I created, especially the bills of exchange. I'm the one who created it years ago. And they're still circulating around today. Some of the bonds, Tim Turner, he's the one that created a lot of those. However, I have been making my own bonds. Now, if you're interested in some of these things I'm talking about, you're welcome to come over to spcuniversity.com. Right now, it's $49 to join. It's going up to $99. We have a class tonight at 9 o'clock, and we also have on Thursday a class at 9 o'clock. Right now, though, we're dealing with trust. But if I get enough people to want to talk about this right here, I'll be more than happy to offer my expertise in this particular subject. I think it'll be elucidating. I think you'll learn a lot. Peace to the gods.